actually all securities are commodity under the Commodity and Exchange Act. It's that we are excluded commodities. But I would agree that a security cannot be also an excluded commodity and an included commodity. I'm sorry, Chair, just to talk about the Commodity Exchange Act more precisely.
Okay, so do you recognize, how would you categorize ether then?
Look, I think that the general sweep of what Congress did, not just in the 30s, but as amended.
I'm asking you,
years,
sitting in your chair now, to make an assessment under the laws as exist. Is ether a commodity or a security?
Without speaking to any one.
I know you've repeatedly said that you're not going to speak to
facts.
one, except you've spoken to one, Bitcoin. So I'm asking you to speak to a second one, the second largest market cap here.
In 2020, the SEC and the chairman, Gary Gensler, charged Ripple with breaking U.S. securities law. If Gary Gensler cannot answer if Ethereum is a commodity now, what is next for XRP? Stay tuned as I walk you through the latest updates on the Ripple SEC lawsuit.
We good?
Ripple is a cryptocurrency network that seeks to provide financial institutions with rapid and low-cost cross-border payments. Ripple is powered by the XRP cryptocurrency, first introduced in 2013 to raise funding for the company's operations. After going through their initial coin offering, ICO, to raise funding to operate their business, Ripple raised more than $1 billion to help manage the firm. However, the SEC sued Ripple Labs in December 2020, alleging that it raised $1.3 billion by selling XRP through unregistered security transactions. While Ripple has not denied the sale of XRP, Ripple CEO Garlinghouse defended the company, claiming that the sales were legal. The Howey test, which evaluates whether an asset is a security, was the foundation of his defense, because no set rules determine if a cryptocurrency is a security. The Hinman documents, which were critical in reaffirming Ripple's position that XRP is not a security, were received by the Ripple legal team on October 20, 2022. However, the SEC filed an application to keep the Hinman documents out of the public domain on December 22, 2022. Dear Judge Tories, pursuant to the court's November 4, 2022 order, DE 695, the SEC respectfully submits this motion to seal certain portions of the parties' filings in connection with their motions for summary judgment. The SEC's requests for sealing relate to three categories of information. 1. Names and other identifying information of the SEC's experts and XRP investor declarants. 2. Personal and financial information. And 3. Internal SEC documents reflecting debate and deliberation by SEC officials. Case 120 CV10832 ATS and Documents 745. Since the Hinman document is being prevented from being used by Ripple, is there a way out? Stick around to find.
Great.
Ripple and the SEC, chaired by Gary Gensler, have been back and forth on the court proceedings, despite Ripple CEO's belief that settling with the SEC is a good idea. The SEC recently claimed that the Howey test does not necessitate a separate fair notice to Ripple. Ripple issued a rebuttal to the Securities and Exchange Commission's letter of supplemental authority, arguing that the SEC's arguments were incorrect. To support its petition for summary judgment, the SEC cited a Massachusetts District Court finding in the case against Commonwealth Equity Services LLC, stating that the decision reaffirms the Howey test does not require a separate fair notice to Ripple. Ripple's response explained why the Commonwealth case does not provide the SEC jurisdiction to reject the reasonable notice defense. Ripple's defense team argues that, unlike Commonwealth, Ripple has given considerable evidence from SEC filings and third-party correspondence, demonstrating that market participants did not believe XRP sales to be an investment contract. Subscribe to the channel and put on notifications so that you can catch all of our educational, analytical, and exclusive crypto videos that will enhance your crypto knowledge.
I subscribe to that.
The first paragraph of the filing reads, Dear Judge Tories, Defendants Ripple Labs Incorporated, Bradley Garlinghouse, and Christian A. Larson, collectively defendants, respectfully respond to the SEC's notice of the supplemental authority, which asserts that SEC v. Commonwealth Equity Serves, LLC, number 119 CV11655 2023 WL2 838691D Mass. April 7, 2023, an out-of-circuit, unpublished district court opinion provides additional authority for rejecting defendant's fair notice defense, Case 120 CV10832, ATESN Document 818. Furthermore, the Investment Advisors Act's applicability in the Commonwealth case was unquestioned, whereas the Securities Act's relevance in Ripple's case remains debatable. The two decisions, according to Ripple, are not similar, and the SEC's reliance on the Commonwealth case is immaterial. Instead, the Ripple defense team cites the Upton case as a binding precedent, which favors the defendant's fair notice defense. Moreover, in Commonwealth, there was no dispute that the Investment Advisors Act applied to the defendant's conduct and required the defendant to disclose economic conflicts of interest. In this case, the threshold issue and source of widespread regulatory uncertainty is whether the Securities Act even applies to defendants' offers and sales of XRP. It does not. The Ripple defense team stated in the third paragraph of the filing. You will be shocked to find out that Gary Gensler couldn't answer if a cryptocurrency is a security or not. Stay tuned as I will discuss this shortly. SEC Chairman Gary Gensler has been loud and strict about the Ripple SEC case since it began in 2020. This can be seen in Gary's back and forth with Ripple and even charging other crypto businesses with violating securities legislation. Recently, Gary Gensler testified before Congress, and Chairman McHenry brought up the Hinman document issue, interrogating Chair Gensler on whether Ethereum was a security, and Gary couldn't answer. This is how it went.
Ether is one of the most popular digital assets and powers the Ethereum blockchain. Back in 2018, then SEC Corporation Finance Director Bill Hinman stated that he believed Ether was not a security. Last month, CFTC Chair Benham expressed his view that Ether is a commodity. The State Attorney General of New York asserted in a court filing last month that Ether is a security. Clearly, an asset cannot be both a commodity and a security. Do you agree?
Actually, all securities are commodity under the Commodity and Exchange Act. It's that we are excluded commodities. But I would agree that a security cannot be also an excluded commodity and an included commodity. I'm sorry, Chair, just to talk about the Commodity Exchange Act more precisely.
Okay, so do you recognize, how would you categorize Ether then?
Look, I think that the general sweep of what Congress did, not just in the 30s, but as amended.
I'm asking you, sitting in your chair now, to make an assessment under the laws as exist. Is Ether a commodity or a security?
Without speaking to any one.
I know you've repeatedly said you're not going to speak to one, except you've spoken to one, Bitcoin. So I'm asking you to speak to a second one, the second largest market cap here.
And speaking to the tokens, there's 10 to 12,000. If there's a group of entrepreneurs in the
asking
middle,
about one.
The public is anticipating a profit based on the...
I'm asking you a specific question, Chair Gensler.
As the XRP SEC lawsuit ends, many institutional crypto investors are eyeing XRP and accumulating in high numbers waiting for the case to end. Check out our video analysis on how only 1,000 XRP can make you rich to know the right time to buy XRP as a retail investor.
Don't forget to like, comment, and subscribe.